Welcome, everyone. This is Ronkat Usman with JBS International, and thank you for joining us for today's 42 CFR Part 2, the Basics webinar. Before we begin, I would like to review some housekeeping items. Due to the high number of participants on this call, all participant lines will be muted for the duration of this webinar session. If you have any comments or questions, please submit them at any time by using the Q&A feature. To open your Q&A window, please click on the Q&A icon located in the bottom center of your Zoom window. If you experience any technical issues during this webinar, please message us using the chat feature, which is located at the bottom center of your screen, or email us at rcore-ta@jbsinternational.com. Lastly, this is a recorded event and your participation grants consent to be recorded. The recorded webinar and PowerPoint slides will be available and sent to participants at a later date. Today's presenter is Kimberly Johnson. Kim, I'll turn it over to you.
Thank you. Hello, everybody. Thanks for joining today. I'm happy to be here. I guess I want to say, first of all, I'm not an attorney. This is my disclaimer. I am not an attorney. This presentation is not legal advice. I'm a researcher and a former director of CSAT, and spent my first year at CSAT deeply involved in writing the 2017, or trying to get past the 2017 rule changes for 42 CFR Part 2. So that's my expertise, is having been involved in that process pretty significantly. And also having run a Part 2 program, so having lived with these regulations for many years before. Next slide. Thanks. So this is what I'm covering today. I just want to cover the statute and its purpose, a little bit of the history of the regulatory changes. I'm going to cover applicability, who Part 2 applies to, and then a little bit of a comparison to HIPAA. And I want to leave plenty of time for questions and answers. Next slide. So the interesting thing about this law was that it was passed in 1971 as part of the Nixon War on Drugs package. And I just think that's fascinating to think about somebody, I don't know that it was Nixon himself, but somebody in Congress or in his administration had the foresight to think about this question of trying to make sure that when people go to treatment, they don't create risk for themselves in terms of law enforcement, of getting into trouble with the law. So we know that drug use is illegal, and that there can be negative consequences for someone's drug use behavior being exposed to law enforcement. And so when they passed all the war on drug laws, one of the laws that they passed was this law about confidentiality of records of substance use disorder treatment. So the goal was that people that are in treatment should not be at greater risk of being arrested or prosecuted or for any law enforcement action than people who are not in treatment or don't go to treatment. And so this law was, so you have to think about, like, that's the context of the law. It's still very much necessary, and you know, it was passed at a time when we didn't have electronic records and everything was on paper, and many, many years before HIPAA. Next slide. So I'm just going to go through the sections a little bit, and this one's the least interesting. So this is the first section, 2.1, the statutory authority for confidentiality of substance use disorder patient records. And it basically says that the secretary, and at the time that the law was first passed, I think it was HEW, Health, Education, and Welfare. And of course, now it's Department of Health and Human Services, DHHS. And one of the rule changes that's happened over the years is to change the name of the department secretary that has the authority to write the rules. So that's the first section of the law. Next slide. So these other sections are of more interest. 2.2, purpose and effect. The purpose of the regulations are to impose restrictions upon the disclosure and the use of substance use disorder patient records, which are maintained in connection with the performance of any Part 2 program. And we're going to get into a little bit later what that definition of Part 2 program is. And the subparts are the general provisions, including the definitions, which get revised periodically during those times that we've redone the regulations, who the law is applicable to, and any general restrictions. Subpart C is the disclosure with patient consent. Subpart D is disclosures without patient consent, including those which do not require an authorizing court order. And subpart E is about the court orders authorizing disclosure and how they get used. And so that's sort of the structure of that section. Next slide. And this next section is section B, and it's the effect, and that's first the regulations and the part prohibit the disclosure and use of patient records unless certain circumstances exist, and we'll get into that. And if the circumstances exist under which disclosure is permitted, that circumstances that it removes the prohibition but does not compel disclosure. So it allows but does not require disclosure. And I think that's something just to be conscious of, that the disclosure is not, except for under the circumstances of the court order, is not required. And they are not intended to direct the manner in which research, treatment, and evaluation are carried out. They're just intended to protect those particular records from being disclosed without patient consent. And the other thing that's kind of interesting is the penalty is a criminal penalty initially in the statute and in their first regulations. And so they're construed in favor of the potential violator in the same manner as a criminal statute, which means innocent until proven guilty. And it also is that it's not just preponderance of evidence, it's what's the other thing called? It's the higher standard that criminal law is held to. So it makes it very clear that it's in criminal law and not in other kinds of law that this initially anyway was enforced. And I'll get to that in the next slide. Next slide. So it's a criminal penalty for violation. It's a federal statute, so it can only be prosecuted by the U.S. attorneys. And let's just go to the next slide, I think, before I say more about that. So the report of the violation has to be reported to a U.S. attorney, except for when it's regarding an opioid treatment program, and then it can be reported to SAMHSA in addition to the U.S. Attorney's Office. So when I was at CSAT, I had a call once from an AG, a state AG, and she wanted to know, she couldn't find any case law. And I had to explain to her that there wasn't any, that this law had never been prosecuted. There'd never been a case. The U.S. attorneys had never brought a case around this statute, this law, and also that she couldn't actually do anything about it in her role. She would have to get the U.S. attorney to bring the case if she had concerns, which of course you can imagine that kind of killed that potential action. So much stronger, I guess I'll say, that comparing to HIPAA, it's a much stronger law in terms of protection, in terms of how violations are addressed. So next slide. So the regulatory history, so the law passed in 71, the initial rules became effective in 1975. There were significant changes to the rules in 1987, 2017, 2018, and 2020. And then the CARES Act, which I'll talk about just at the end. Last year, March 27th, President Trump signed the CARES Act, and that has some changes to the statute that I say will be effective this month, but would be effective no sooner than March 27th, 2021. And their rules have not been published, and so I don't believe that it can take effect until there are rules in place to affect those changes in the statute. And I'll talk about what those are in a little bit. So we didn't touch it for a really long time, and then we messed with the rules in 2017, 2018, and 2020. And the reason for that is a couple things. That primarily, well, two reasons. That we spanned two administrations, so the 2017 rules actually had begun to be put, the notice of proposed rulemaking had been put out under the Obama administration, and then they were passed under the Trump administration. And so you have two administrations with different perspectives on this law. And so 2018 and 2020 went a little bit further, or some might say quite a bit further than 2017. And also I think the other thing is that once you start, so let me just talk about the rulemaking process just a little bit at the federal level, is that, so you put out the notice of proposed rulemaking after, I mean, most federal agencies do a lot of work before they put out the initial notice internally, so that the rules don't contradict other rules that are in process, or other laws in other parts of government. And also in Sam's case, they had held a public hearing, at least one, maybe two, prior to writing the rewrite of the rules in 2017. And so the notice came out in 2016, I think early 2016. And so what happens, you put out the notice, you accept comments, and then you have the choice of making the changes you proposed or not. And the comments may propose useful things or things that you hadn't thought of in the writing process of the rules, the internal writing process, that or raise problems that nobody thought of in the rule writing process that have to be put out to public comment again. So you can't just respond to commenters by saying, oh, you're right, and we have to fix this now. Anything that you want to change has to go back out to public comment. And so the reason 2017, 2018, and 2020 is each one of those was an iteration of, 2018 in particular really fixed some things that we couldn't fix and still pass the regulations as changes as we did in 2017. And so that process, 2017, 2018, and 2020, was an evolution of trying to, as much as possible within the statute and the purpose of the statute, move the language so that it matched HIPAA better, so that it would be less confusing for providers. And the CARES Act changes really, which are obviously not in effect yet, really change the statute so that it's much more in line with HIPAA. Okay, next slide. So I'll get into some of the details of the things that I think are most relevant to you all, and then if I've missed something that you all think is important, you can post a question in the questions and answers, and hopefully I can answer the question or point you to where to get the answer. Okay, so some of the key provisions. The records of the identity, diagnosis, prognosis, or treatment of any patient which are maintained in connection with the performance of any program or activity relating to, and this is sort of interesting, this original language, because it's so broad, and of course the rules narrowed it, relating to substance abuse education, prevention, training, treatment, rehabilitation, or research, which is conducted, regulated, or directly or indirectly assisted by any department or agency of the United States, some other stuff in there, shall be confidential. However, substance use disorder records may be disclosed as permitted with prior written consent of the patient. So obviously, that it's much more narrow now in terms of we're talking about treatment, not prevention, not training. So let me just get a little bit into it. What consent means, I guess that's what I really want to talk about here, is what that means. However, SUD records may be disclosed as permitted with prior written consent. So pretty much anything that you want to do, any sharing that you want to do is allowable with patient consent. And the consent has to be written and in a certain format. The Legal Action Center, I have their website on the last slide, and I think they'll put it in the chat at the end, has some templates that you can use for what needs to go into a consent document to make it compliant with Part 2. You have to, the name of the patient, the name of the program that's making the disclosure, the purpose of the disclosure, who is to receive the information, and that can be an organization. It doesn't have to be an individual. That was one of the changes in 2018. It can also be a general consent. So for example, it could go to a health information exchange as a general consent. The part in kind, so the specific information that the patient is consenting to releasing, and that I think that's that's critical, is to be very specific about what it is that's being released. Even if you're saying all records, it has to be very specific to what that means. That the patient, the consent form has to have that the patient understands that he or she can revoke their consent at any time, and let them understand that any information that's already been released is out there, but you can revoke any future releases. And that the revocation can be oral as well as written. They can just tell you. The date upon which the consent expires and the date that the form is signed, and it needs to be signed by the patient. It needs to contain the notification of prohibition of redisclosure, in either the long format or the short format that we came up with in 2017 that matches the field length that would work in electronic data exchange. So if a patient consents, you can share pretty much anything as long as they say that it's okay with them in writing. And back in the days of paper, that's how a Part 2 program would function. We would have our list of people that we wanted to discuss the patient's care, whether they were social service providers, whether they were other medical providers, child welfare, whoever it was, and the patient, we would just go through having the patient sign the consents. And I think it very much works that way in many places still, where people just ask patients to consent to the transfer of information, and it's relatively rare that patients say no. Okay, let's go to the next slide. There are some circumstances that are exceptions to the requirement for consent. One is under a medical emergency. So information could be shared to medical personnel when there is a medical emergency. And so there's a research exception that information can be shared for research, that it can be shared for audits and program evaluation, although in any of those reports, whether they're research reports or audit reports, that can't disclose individuals' particular information, and if authorized by a court order that shows good cause. except for under the court order, no record can be used to initiate or substantiate criminal charges. So again, it goes back to this purpose of this law, which is to protect people in treatment from being, from having their information used against them by law enforcement. And so, so a court order is not a subpoena, I guess, and that's one thing that I think is critical and different from HIPAA, is that we aren't talking about subpoenas. A court order is a whole other level. A judge has to sign it. When I ran a residential program, it was pretty routine for a sheriff from from somewhere to come with a, I used to call them tear-off sheet subpoenas, back when that's what they were, and I'd have to say, no, this is inadequate, come back with a legitimate court order. And they almost never did. I mean, a judge would almost never sign off on their fishing exhibitions to my facility, and I understand from talking with Part 2 providers that this is still a pretty routine use of this statute, which is to to protect patients from being hauled out of treatment by law enforcement, or protect their records from being used against them or seized by law enforcement. And you have the right to not even report that a person is present in a facility. So you don't need to even disclose that if a law enforcement official comes looking for somebody at a treatment program. And so this court order, the higher standard from a subpoena has been really important to treatment programs in terms of protecting their records and their patients from law enforcement action, specifically related to people's substance use disorders. Let's go to the next slide. So I know one of the questions people have a lot is, what is a Part 2 program? I'm going to do that on the next slide. But this is it shouldn't be complicated, but it is because the law is relatively, or the rules are relatively vague and somewhat deliberately vague, so as to not put in or leave out organizations by accident. So I'll talk about applicability. And so the question you ask is the information or the program that collects the information, is it protected by Part 2? And then ask the question, if it's applicable, is this covered by one of the exceptions to consent, or one of the exclusions from consent? And if so, or if not, will the patient consent to the disclosure? And if the patient won't consent, is it something that could be court ordered? And so this is sort of the, I guess, the thought process to go through. Like, does this information apply? Is it Part 2? Is it covered by Part 2? If it is covered by Part 2, is the disclosure one of those exceptions that's allowable? If not, can we get patient consent? And if not, then can it be court ordered? So that's sort of the stepwise process about if someone wants to disclose information that's Part 2 information. Okay, let's go to the next slide. So hopefully you aren't watching this on a phone and you can see this document. This comes from, this is an image from the SAMHSA funded Technical Assistance Center on, that's for Part 2, and I have a link to that at the end. And so this is the whole issue of applicability, and do I run a Part 2 program? Does it apply to me and the data I collect on my patients? So the federally assisted is pretty clear. Probably everyone on this call falls under the yes for that. So if you get Medicaid payments, if you get like FQHCs would all fall under federally assisted. The only, it's sort of interesting, there may be some of the sort of high-end residential substance abuse programs that don't take government payments, maybe don't fall under the federally assisted, so may not have this law apply to them. But generally speaking, pretty much any healthcare service would answer yes to federally assisted. And then the real question that everyone is like, well, do you work in an identified substance use disorder unit? And the rules, so this, we grappled with this question a lot in the 2017 rulemaking process. Like, do we put a number that if 50% of your patients or 50% of the work that you do, or, where do you draw the line where you are defined as a substance use disorder provider? And it has been not that clear, I think, to most organizations, particularly, I know some FQHCs who have residential treatment programs that they run, or specific units that are substance use disorder units. And those programs, those specific programs, would be Part 2 programs. And so the way to think about it is, do you hold yourself out? Meaning, do you advertise? Do people come there specifically for substance use disorder treatment and nothing else? Is that particular unit or that provider specifically doing substance use disorder treatment? And I would use a relatively high bar. Is this perceived of as a substance use disorder treatment program? And not say, well, we 50% of our patients have substance use disorders, or something like that. It's like, do you hold yourself out to the community as a substance use disorder program? And then if the answer to that is yes, then you're a Part 2 program. So it's the hold yourself out and the primary function. And the primary function is where people say, well, primary, what does that mean? And I would apply those two things. Do people perceive of you as a Part 2 program, as a substance use disorder program? And again, remember, I'm not a lawyer, I'm not giving you legal advice, but that was what we were thinking when we were working on those rules, and how or whether, how much to try to clarify that language. And so this is something that SAMHSA, this decision tree is something that SAMHSA has funded the Legal Action Center and the center that they set up on protected health information to come up with. And so I think it's a good decision tree. And if you have sort of case examples that you want to talk about when we get to the question and answer section, we can go through that. Next slide. Okay, so all of the regulatory changes that we made in 2017 and that were made in 2018 and 2020 were really all designed to try to align Part 2 with HIPAA. And as the person that was responsible at CISA at that point in time, it was a little irritating because Part 2 was many years before HIPAA. But be that as it may, even without HIPAA, we had to figure out how to make Part 2 work in electronic data transfer environment as opposed to a paper transfer environments. So that was the purpose of all those regulatory changes, to within the scope and capacity that that SAMHSA could do with rule changes as opposed to statute changes, to better align it with HIPAA. And again, under different administrations with different goals. So I would say, the Obama administration was relatively cautious in their approach in making any kind of rule changes, and didn't want to go too far, tried to kind of toe a line of making the changes, but being as cautious and making as few changes as possible. Under the Trump administration, I think the different attitudes, different approach, and it took it much further than the Obama administration did. And in the CARES Act kind of really did, with minor differences, get it as much in line, I think, as you can, without just eliminating the law. So I think that the key difference now, well, once the CARES Act changes happen, the key difference is you still have to have initial consent for disclosure under Part 2, even for treatment, payment, and healthcare operations. Whereas under HIPAA, you just have to inform people. You don't have to get consent. So it's just a slightly different process. And under HIPAA, a subpoena is adequate to obtain records on a patient, but it's still, again, if law enforcement is trying to get records against a patient's will, then it's Part 2 information as opposed to other health information, then a subpoena is inadequate. A court order is required still for Part 2. So I don't know if I want to specifically say anything more than that about the differences. I mean, in the original 2017 regulation changes, we tried to differentiate between what was required under treatment and what was required under payment and healthcare operations, and we avoided putting case management under payment and healthcare operations, and there was a lot of pushback on that, and that got changed, and so that language was specifically added under 2018 or 2020, so that all of the healthcare operations that are I think it's the list of 18 that are in HIPAA are now included as Part 2 requirements as well. So it really does bring it into alignment. So let's go to the next slide. So the CARES Act really will take it to the next level when it becomes effective, and it can't become effective any sooner than March 27th this year, but the rules have to take place, and I have not seen any announcement for the rules, and the people that I know that worked on the 2017 and 2018 rules are not involved in it anymore. And so actually, if any of you have information that you could share about the rulemaking process under the CARES Act, I think probably people will find that useful. But when it does become effective, they will allow redisclosure under the same conditions as HIPAA. So redisclosure right now, it's is prohibited, and that's, I know, one of the issues that in terms of health information exchanges has been such an issue, is that every sharing of Part 2 information has to be under the original intent of the consent, and then has to carry the language against redisclosure. And the CARES Act moves that all towards HIPAA. The interesting thing about the CARES Act is it extends the prohibition on the use of records in criminal proceedings to civil and administrative proceedings. Again, except for when there's a court order or patient consent. So it it actually expands the patient rights in terms of how their information gets used. And it adds an anti-discrimination clause, you know, so as a sort of as a counter to how much broader dissemination of the Part 2 information can be. And it adds the HIPAA civil penalties for wrongful exposure and extends the notice of breach requirements to Part 2 programs. Now, it's kind of interesting because most Part 2 programs are also covered by HIPAA. And so people would have had to do this anyway under the HIPAA, the HIPAA regulations. It's interesting that what it does really is it's still the criminal penalty, but you can also have the civil penalties. And so it kind of brings that, I mean, one of the reasons that had never been adjudicated is because it had to be, you know, a U.S. attorney had to actually bring criminal charges against somebody. And that's a pretty high bar. And so this lowers the bar down to the same as HIPAA. So they tried to add some protection. So even though they were expanding the, you know, the ability to share information beyond the original, what the original regulations were, I think they also attempted to put in protections against the misuse of that information. Again, with going back to that original intent of the statute, which is to protect people in treatment and make sure that they are not punished, basically, for being in treatment, that they are not treated differently because of their being in treatment. So I see there's a bunch of questions. I want to leave time for them. Lisa had said that you had questions about the notice of proposed rulemaking that where comments are due on the 22nd, that is around the HIPAA privacy rule changes. And you know, I was looking at that trying to see, well, is there anything that's specifically related to Part 2 in here? And I couldn't find anything that is specific to Part 2, although there are sections that might affect Part 2. You know, I haven't talked about the QSOA or the business associate disclosure at all. That's in these rules. And so the CARES Act basically makes them the same, the definition is pretty much the same. So this might affect it that way. But anyway, if people had specific questions, I don't know that I can give you legal advice on this, but I don't think this was directed to Part 2 programs in particular, although some of the provisions, because as I said, most organizations that are covered by Part 2 are also covered by HIPAA, may be affected by this. And if there are questions or discussion that people want to raise about it, I'm happy to delve into whatever the specifics are. So my last slide before we get to questions and answers is just some resources. There we go. Okay, so the COEPHI Resource Center, SAMHSA funded a resource center, it's a technical assistance center. If you have questions that this kind of high level discussion doesn't really answer, they're a resource, and they have technical assistance that they can respond to specific questions, and they work with the Legal Action Center. And the Legal Action Center has kind of been the experts on this topic for forever. So that's one resource that I think you should take advantage of. The Legal Action Center is the next one, the lac.org. They have the book that is the fundamentals of Part 2. They also have some templates that you can use for consent and some other documents so that could be useful to you all. And then SAMHSA has the FAQs on the regulations, and it does take a long time for them to put out new FAQs. because because they have to go through clearance, and so it's quite a process to get that kind of information published. But I do believe that they're up to date from up to the 2020 regulatory changes. So I think let's go ahead and open it up to questions or comments, because I think some people had, I saw some things in the chat where people were providing additional information that I think is useful too.
Yeah, that's great, Kim. Thank you for overview of a very technical area, but one that's obviously a lot of people are very interested in. Yeah, some of the comments are in the Q&A, and we'll let you read those. I've identified some of the questions, and again, they're pretty technical, so we'll throw them at you. Somebody asked about SUD prevention. Is it also protected from disclosure unless you have consent, or is it only apply to treatment?
So the original laws talked about prevention, but it's real. I would say no. That it's really, we're talking about treatment records. So like schools, people that participate in school-based prevention programs, it wouldn't apply. Now again, not an attorney. If you have a question about your specific program, you should talk to your attorney.
All right, the next one from Audrey. Would the court-ordered treatment information have to be disclosed on the client?
I'm sorry, would the court-ordered treatment?
Court-ordered treatment information have to be disclosed?
So if the court orders the information, then yes, although that would definitely be a case where you would want to get your attorney involved in the process of handing over that information. But that is when, so if it's a court order in the correct format, which again is why you want your attorney involved, then that is one of the exceptions where you would have to turn over the information. I hope I answered the question.
I think so. Next one, on the ROI, do clients have to initial each box, or can they simply check them along with the signature at the end of the document? Do you know what that refers to?
I'm not 100% sure when they say ROI, but
want to clarify the ROI in the chat? Maybe we'll get back to that.
Yeah.
Tamara says, thanks for today. I'm wondering how to apply this in a hospital-based MAT program. Can the patient records be a part of the regular behavioral health hospital record?
Yeah, so that is one of the complicated situations. And it also depends on what the state laws are about mental health information too, right? So you have these multiple layers of confidentiality regulations and laws and how you apply them. So if it is a MAP program, so if it's a specific program and not just physicians prescribing, right? So if you have like a methadone treatment program, an OTP that's under the hospital umbrella, then that information is Part 2 information. And so then it's a little bit complicated, but the EHRs that I know about, the big ones anyway, which you're probably using either Epic or Cerner, and they both have a way of partitioning out that Part 2 data. And so your question about can it be included in the mental health record? It probably needs, depending on the various state regulations, it probably needs to be separate even from that. But that is definitely the specific details of of what can go with what. Probably is a hospital attorney question. And if you are the hospital attorney, I think then that probably is a good question to approach that Center of Excellence with on the specifics of how to manage that. But just in general, yeah, it would have to be separate.
Okay, thanks for that. And on the ROI, we have 10 participants awarded virtual gold stars for letting us know that's release of information.
Oh,
So do clients on the release of information have to initial each box, or can they simply check them along with the signature at the end?
you know what? I don't know the answer to that. I mean, I would say probably check them, but that's a level of detail I don't know the answer to.
A fair answer. Ashley's asking, does a part 2 outpatient office have to have a SUD patient consent to release their own records to the electronic chart, like my chart, even if they likely will be the only person to access that?
So you can release the records to the person themselves, which I think is what you're saying, like an electronic version of my chart, that the person themselves has a right to access to their own records. And so, unless there would be some way that some other organization or person that shouldn't have access to that information would have access to my chart. And I mean, I have my chart myself, and unless I give someone else access, they don't have it. So I would say that there wouldn't be a reason to not do that. That you should be able to include Part 2 information in someone's my chart record, assuming that they're the only ones that have access to that. You know, if it gave access to some other part of the, or like if putting it in that, I mean, I don't know the back end of that. So if putting it in there somehow made it accessible to others, even if it's other providers, then you wouldn't want to do that. But if the only person that can access that information in that way is the patient, then it's their information and they have a right to it.
All right, good answer. A coverage question again. Would this cover syringe service program participants?
Oh, no, that's an interesting question. So it's interesting because I've never thought of syringe service participants as sort of being documented in some way of receiving those services, but I'm presuming then under the scenario that you're talking about that there's a record of people receiving the syringes. It's interesting. I'm inclined to say I would consider that, but I think there are probably a lot of caveats. But it seems to me if the syringe services are the primary or only purpose of them is to provide them to people who are using drugs, and you're documenting that, then I would say that it probably does fall under Part 2. But that would be a good question to ask an attorney, because I think you'd have to go through those questions, right? Like, I mean, I think you could legitimately say it's a Part 2 service or a Part 2 program, and then it's just going through the other questions on that that decision tree. That's an interesting question.
Yeah, lots of interesting questions. Sometimes people in the audience are typing into the chat window some answers and some responses. So I'm sure you all can multitask and listen to Kim and take a look at that.
Yeah, better than I can. So yeah, so I'm scrolling through to see.
That's what's great about having a huge audience here.
Yeah, and people that are doing it. I mean, I think that's the thing, Yeah.
How about the next one? How does Part 2 apply to deceased individuals, specifically regards to people involved in a community-based overdose fatality review team?
You know what? I should know the answer to this, because I think it's obvious, but I don't actually know the answer to this. So I mean, for other things, confidentiality ends when you die. I'm not sure. Shoot, I should know the answer to this. I apologize because I should know and I don't. You know, some of these we might want to look up after. Yeah,
Well,
sorry.
again, we may have somebody in the audience who's working with an ORT who might
Yeah.
be able to give us some insight on that. Long question from Asa. I work for a nonprofit agency that's grant funded. We're attempting to set up a diversion program to divert individuals with SUD from the criminal justice system into proper treatment. We'll be collecting basic demographic information, criminal history, et cetera. We will also be referring clients to treatment as well as monitoring the individuals through the treatment process. We will not be providing actual treatment. Do these rules and regulations apply to our agency?
So but you're doing referral, right? They said referral. That's one of the activities that they're doing. So can you read again what they're doing?
They're setting up a diversion program, and so they're collecting personal information and referring clients to treatment.
So you're going to have information on their substance use disorder, and you're going to be referring them to treatment. So I think it would apply, but again, I think your specific use case, you probably want to talk to your attorney because there are details that may or may not be related to what you're doing. But I think so. For example, if you were an organization that was doing like assessments, and all you did was assessments and referral to treatment, it would apply to you, right? So that's the kind of thing I'm just trying to think, like, it depends kind of on what you're doing exactly. So yeah, I would check your use case with an attorney, but my inclination is if you're doing any kind of assessment and referral, then it would apply to you.
All right. From Megan, thanks for today. I was wondering about the Part 2 status reverse integrated medical clinic deploying MAT MOUD. They provide mental health, physical health, and SUD outpatient services. I guess they're asking about whether they're covered as well.
Oh, well, it gets into that hold yourself out and primary purpose, right? So I think that the thing is to ask yourself those questions. But I think what you're saying is like, do we have to separate this information out in a medical record, right? So if it's a reverse, yeah, I would stick with those two questions. Ask yourself those two questions. And if the answer to those two questions is yes, then probably Part 2 would apply. Someone did send the answer about deceased, and I did click on that. So for vital statistics, the regulations do not restrict disclosure of patient identified information, including cause of death. And that whoever's the executive administrator of the personal representative of the person who died, if there's a reason, if the consent is required, that person can provide that consent. So I don't know that really gets to the question of like for vital statistics. I mean, it's going to be in the death record, and so if you have access to those death records, then if that's what you're talking about in terms of the review group, then I would say you have authority to use that information. Now, if you're talking about all the other records, I think the way I'm looking at this, it's saying that you probably need consent for those other records, and that you could get them from whoever the right person from the family is.
Okay, we have time for about five more minutes. A COVID era question. With so much SUD services currently being provided virtually or over the phone, is initial written consent still required? So how is that handled?
Yeah, yes, and there's actually a bunch of language in the rules about electronic signatures, but yes, it is required, but you can get electronic signatures. You don't have to have a handwritten signature.
All right.
So written consent is it can't be verbal consent. It still has to be written, but written now means electronic.
All right. And Jerry's added a lot of great information and comments. This is one of his questions. What about a federally court-ordered person as part of a federally sponsored pretrial parole and probation condition of release? Does the client have the right to revoke the federal court's access to the record? Even if part of the court-ordered admission was the court would have access to the records.
Yeah, that's a tricky one, isn't it? Yeah. So yes, but there are probably consequences that were assigned in the court. The whole process about their revoking this comes up with drug courts too. Although your example is a much more extreme case. So the patient has the right to revoke, and you have to respect that. And then what those consequences are is kind of, that's maybe a clinical issue you want to discuss with the patient. And the court can always court order records, right? So if they so choose to do that, so that's the trick there. So did they already court order the access to the records, or the patient consent to the records? And it's like, which of those paths are you sharing information on? And if it's under patient consent, even if the patient was court ordered into treatment and sort of coerced into signing that consent, if they revoke it, then you have to go by the consent rules, and the court can do what they need to do. And the patient will deal with whatever the consequences the court had for that. But so hopefully that answered that question.
All right, the next one's from Cherish. This one I think you should be able to answer. So if you're a private practice assessing and treating SUD, would it not apply because it's not federally funded?
So it might not apply if you don't get any so federal funding, but also federal oversight. So that could mean a lot of different things. But like if you get Medicaid payments or Medicare payments, that makes you fall under it. So you might fall under the federally supported, but not then as a private practice fall under the part, the hold yourself out, or that's the primary thing you do. So so that's the other category, right? So if you're like a private practice physician and you're treating other illnesses, that might not happen. If you're talking about like a private practice social worker or psychologist or something, and you're only treating substance use disorders, then you might fall under it if you're accepting other payments. But if you're not like if you only take people paying out of pocket, and there isn't some other way that you fall under that federal oversight umbrella, then you aren't a Part 2 program. So some of the fancy treatment programs don't fall under that umbrella for that reason. So you may not, but you have to ask yourself those questions.
All right, thanks for that, Kim. Okay, we're going to enter the bonus round. There's some real short questions. We'll try to get those into the last couple minutes. Is there a difference between receiving a court order from a state court versus federal court?
So the court order doesn't have to come from the federal court. It can be signed by any judge, so the short answer, no, not for this purpose.
And a similar kind of jurisdictional issue is a court order signed by a magistrate enforced, or does it have to be a judge?
So I believe it has to be a judge, but it probably depends on the state and what the definition of what people. So this is where my not being an attorney is not helpful. I believe it's a judge, but that's probably a lawyer question.
Okay. All right, and we'll get to one more. It's a quickie. Do you know how many years the records have to be retained from the last contact? Is that part of this law or governed elsewhere?
I think it's governed elsewhere. I don't think there's anything in part 2 that says, there's the stuff in part 2 about how you have to dispose of records and what happens to them if your program closes, but I don't think there's anything in this statute or regulations that talks to the length of time you have to retain records. And you know, HIPAA covers that there. And so anyway, that's covered elsewhere.
And I think we'll stop it there. We got to a whole lot of questions. Thank you very much, Kim. We covered a lot of ground today.
Go ahead.
That concludes our Q&A portion. We would like to thank you again for your participation. Have a great rest of your day. Thank you.